The day I discovered the $14 million government-backed fund, I finally understood why the HOA had spent years trying to destroy me. They didn't want my property because of a fence. They didn't want my shoreline because of some community rule. And they certainly didn't care about an illegal gate. They wanted my land because controlling it could unlock a development project worth tens of millions of dollars. And the people behind it had been planning everything for years. But what I didn't know was that the final piece of their plan was already sitting inside a government office. My attorney called me just after sunrise. "Daniel, you need to come to my office immediately." His voice was unusually serious. When I arrived, he placed a thick evidence folder on the table. The investigators traced the $14 million. I opened the folder. The first page was a federal development funding agreement. The second page showed Cedar Cove. The third page showed my property, and beside my shoreline was a handwritten note, "Required access corridor." I looked at my attorney. "They were going to use public money to build this?" He nodded. "But that's not even the worst part." He turned the page. The government-backed funding application had been submitted nearly 2 years before the HOA ever claimed my property violated community rules. That meant the development plan existed before the fines, before the gate, before the fake surveys, before the lawsuits. The HOA wasn't reacting to problems. They were creating problems to make their development plan possible. For years, I had believed Karen was simply an overpowered HOA president who had become obsessed with controlling my property. Now I realized she had been following instructions. And Richard Hale wasn't simply a corrupt developer. He had built an entire network around Cedar Cove. But there was still one question. How had they convinced a government agency to support the project? Investigators subpoenaed the original funding application. When the documents arrived, everyone in the room went silent. The application claimed that Cedar Cove had limited public access to the lake. It claimed the community needed a new shoreline corridor for emergency services. It claimed several homeowners had already agreed to provide access, and one of those homeowners was me. Except I had never signed anything. Investigators compared the signature to my actual driver's license and property documents. It was obviously forged, but the application had been approved anyway. That changed the entire investigation. This was no longer just an HOA dispute. Someone had used fraudulent property records to obtain government-backed funding. Investigators immediately contacted the agency responsible for the program. Within hours, the funding was frozen. Construction payments stopped. Contractors were ordered not to begin work. And the development company suddenly had a serious problem. Without the $14 million, the entire project could collapse. But Richard wasn't finished. That afternoon, he called an emergency meeting with his attorneys. Investigators were listening. According to the recorded conversation, Richard said, "We don't need the entire property." One attorney asked what he meant. Richard replied, "We only need the corridor." My attorney played that recording for me. I finally understood. They didn't necessarily need to own my entire property. They needed legal control over a narrow strip of my shoreline. If they could obtain that strip, they could connect the proposed development to the lake. That corridor was the key. And suddenly, every strange thing that had happened over the previous years made sense. The HOA's original gate had been positioned near the exact location of the proposed corridor. The fake survey had drawn a boundary across the same section. The fines had focused on structures near the shoreline. Even the old complaint about my fence had targeted the same area. They had been testing ways to establish control. When those attempts failed, they escalated, but investigators still needed proof connecting Richard to the forged funding application. Then a former employee came forward. His name was Michael. He had worked for Richard's development company for almost 5 years. He told investigators he had become uncomfortable with the project months earlier. He had seen documents that didn't look right. He had seen payments that didn't make sense. And he had been ordered to destroy old drafts of the development plan. But Michael had kept copies. He brought investigators a small storage box. Inside were printed emails, invoices, meeting notes, and handwritten instructions. One document was dated 7 years earlier. At the top it said, "Cedar Cove Waterfront Strategy." Below it was a list of objectives. Number 1, acquire surrounding properties. Number 2, establish shoreline access. Number 3, increase development valuation. Number 4, resolve resistant homeowners. My name appeared under number 4. But there was something beside my name I had never seen before, a dollar amount, $620,000. That was their original target purchase price for my property. Investigators compared it to the property's projected value after development, more than $2.8 million. They had planned to pressure me into selling for a fraction of what the property could become worth. And the plan wasn't theoretical. A financial spreadsheet showed exactly how the profits would be divided. The developers, the investors, the construction company, and several people connected to the HOA. But one category stood out. Government facilitation. Beside it was a 6-figure amount. My attorney stared at the page. Someone was being paid to make the government process easier. Investigators immediately focused on the county official who had attended the secret meeting. They subpoenaed his bank records. 3 days later, they found a payment, then another, then another. Over 2 years, more than $180,000 had been transferred to a consulting company owned by his brother. The payments were disguised as environmental consulting fees, but the company had never performed environmental work. The official was placed under investigation. Richard's attorneys immediately claimed the payments were legitimate. Then Michael produced the invoice instructions. Each payment had been labeled internally access facilitation. The case exploded. News crews arrived outside the courthouse. Homeowners who had spent years fighting the HOA started coming forward. One woman said the HOA had threatened to place a lien on her home unless she agreed to sell part of her property. Another homeowner produced an old letter demanding that he sign an access agreement. A third homeowner revealed that she had been offered $40,000 for land worth nearly $200,000. Suddenly, Daniel's case wasn't isolated. There were dozens of homeowners, and the same strategy had been used against almost all of them. Pressure, fines, threats, legal notices, then lowball offers. The goal was simple: make people desperate enough to sell. But the biggest revelation came from Karen herself. After investigators confronted her with the financial records, she requested a private meeting. My attorney was there. The state investigator was there. Karen sat across the table looking completely different from the woman who had once stood outside my property screaming about HOA rules. She looked exhausted. The investigator placed the master file on the table. "You can continue denying everything," he said, "or you can explain who gave you the instructions." Karen stared at the folder. For almost a minute, she said nothing. Then she whispered, "It wasn't Richard." Everyone looked at her. She continued, "Richard was involved, but he wasn't the first person." My attorney leaned forward. "Who was?" Karen looked directly at me. "The original land consortium." I didn't understand. She explained that before Cedar Cove became a residential community, the land had been controlled by a private investment group. Richard had worked for them. The HOA had been created partly to make the community easier to manage after development, but the investment group had retained rights to future development in several areas. One of those areas included the shoreline surrounding my property. Then Karen said something that made the entire room silent. "Your property was never supposed to remain private." I stared at her. "What do you mean?" She explained that the original development plan assumed my property would eventually become part of a larger waterfront project. But when the previous owner refused to sell, the entire plan stalled. Then I purchased the property years later, and I unknowingly became the final obstacle. That was why the pressure started. Not because of an HOA rule, not because of a fence, because I owned the one parcel they needed. My attorney asked Karen the final question: who is still controlling the project? Karen looked down. "I don't know." The investigator pushed the documents toward her. "You know more than you're saying." Karen hesitated. Then she wrote a name on a piece of paper. She pushed it across the table. My attorney picked it up. His expression changed. I asked him what was wrong. He handed me the paper. The name meant nothing to me, but beneath it was a title: Managing Partner, Cedar Development Consortium. My attorney hadn't filed anything, and the court had already frozen the development. Someone was still trying to create a legal claim against my shoreline. Investigators traced the filing. It had been submitted electronically at 2:13 a.m. The account belonged to a law firm, but the law firm claimed they hadn't filed it. Their login credentials had been stolen. Someone had broken into the account.